Good morning. This is John Callis, President and CEO of Castle Breckenridge Management, Inc. This is Monday, April 3rd. We're very fortunate to have as our special guest today is Joel Kriger, Senior Associate and owner of the Kriger firm in La Mesa, California. He is an expert on business contracts. And if I recall correctly, Joel, you taught contracts at San Diego State 10 years. He's going to speak today on contract formation and how to save money and look out for pitfalls when a homeowners association does so. It's my pleasure to introduce Joel. Let's give him a big round of applause.
Thank you, John. So today we're talking about vendor contracts, things HOAs need to watch out for with vendor contracts. Things you don't watch out for could cost you money. You could be stuck in a vendor contract for sometimes it seems like eternity, because sometimes they have these automatic renewal provisions that keep you locked into their services for way longer than you want. So we're going to talk about all that today. Two basic kinds of vendor contracts you'll be dealing with. There's the one-time project vendor contracts where you have you may have a $100,000 painting project. And then the other type of vendor contract are those contracts that are long-term service contracts, like the laundry contracts and the landscape contracts and vendors who do maintenance. So those are a lot of the same things apply to both, but there's a little differences that you want to look at in each. The common thing that you want to look at in all the contracts is, we'll talk about licensing. You want to make sure your contractor has a valid contractor's license. That's an easy thing to check. It can be done on the internet. You just go to the State Contractors License Board and make sure that that's in place. That's important for a bunch of different reasons, but one is there's a contractor's state license bond that if there's a claim to be made, it's a small bond, $12,000, that is available. And it also is credibility. If your contractor can't even keep a current license, you definitely don't want to do business with him. The other thing in both kinds of contracts you want to look at is insurance, and that's for management. That's an HOA board. That's typically one thing you want to check. It's important that they have liability insurance, because if they come onto your property and damage it, perhaps start a fire, leave their materials out, somebody gets injured because they trip over it, you need to make sure that they have the liability insurance so that claim can be made and the association is not going to be held responsible for the vendor. Other thing that's important is if it's not a one-person contractor, that they have workers' compensation insurance. And again, the HOA can be held responsible if they don't have the workers' comp. So the insurance is important. That's an easy thing to check. And those are after you initially select a contractor, you want to check his license out on the contractor's state license board. You can usually find the contractor's license number right on the contract. They typically put it right there. And then insurance is just, you have to request it. You'll get a they call it a deck page, but a declaration page of the insurance, and you can see if that's current, and you're off and running with the insurance. Another thing to look at and consider is governing documents. There are restrictions in governing documents about the types of contracts you can go enter into. You'll see in usually older documents, they call it capital improvements. If you're going to, and the interesting thing about capital improvements is they limit the board to entering into a contract for capital improvements unless you get the membership approval. The thing with that is, it's always mystified me as a lawyer, is they use the term capital improvements, but they never tell you what they are exactly. So my opinion is that a capital improvement wouldn't be repairing your roof for $50,000 where you've saved up money in reserves, or repairing anything that's just already on site that's a normal maintenance item. A capital improvement, in my opinion, would be adding some new amenity that the HOA didn't have before. They're going to add a jacuzzi or build a structure that they didn't have before. That would be a capital improvement. But again, the limitation on the board proceeding with a capital improvement is only if it's contained in the CC&Rs. It's not a limitation in the law. And if there is a limitation like that, generally it requires a membership approval. Sometimes governing documents, especially the older ones, will put a dollar limit on how much a board can contract for without membership approval. So those are things you can easily find, but you just have to look through the documents and check that out. Another limitation in your governing documents that's virtually in all of them is they limit the contracts to 1 year without membership approval. And the concept behind that is that the boards change every year. There's an annual meeting, and they don't want, the wisdom there is we don't want the board obligated for the next 5 years on a contract that they didn't make. And there's exceptions to that, laundry contracts, and documents typically make exceptions, but as a general rule, when you can avoid it, do not go make contracts for more than 1 year. I mean, they can always be renewed after the year. So that's really not a problem. On larger contracts, you should have a legal review. Even smaller ones, smaller contracts for smaller dollar amounts are a page or two. It only maybe take a lawyer 15 or 20 minutes to glance at it. So there's not that much expense there. The parties in the contract, this is important for boards of directors. You have the party in the contract should always be the HOA, the association corporation. We don't want any of our board members named as contracting parties because they could create personal liability. And we want to protect our board members, and you as board members want to protect yourselves. So you never want your name on the contract except to sign the contract in a representative capacity. I'm signing as president or secretary of the association. That's what you want. You're an agent of the corporation. You don't have personal liability for that. Another thing that I want to talk about is scope of work. And this one's very important. It's not so critical for those contracts that are ongoing, like the laundry contract or the landscape contract. I mean, it's important, but not as important as for the projects with the big dollars. The ones for the $100,000 or the $200,000 roof replacement or other, a lot of associations have extreme amounts of deferred maintenance. And it's not uncommon for those associations one day to wake up and say, we're on the verge of having our buildings condemned if we don't do something, about it quickly. And large special assessments are passed, and there's large contracts are written for a lot of work throughout the property. So there, the scope of work is very important, and it should be reviewed by a construction consultant or a construction manager so the board and the management understand what you're getting, because if it's not in the scope of work, and you maybe believe it was, or maybe it was even discussed when the contractor came to make his presentation to the board member, but if it's not in the contract as a scope of work, it's not covered. So you're paying $100,000 for this project, and you thought these items were covered and you were included, well, not in the scope of work. Guess what? That's what's known as a change order. And that's how a lot of contractors can make most of their money and profit, is by change orders, because it wasn't clear in the scope of work that they had to do that. So scope of work is important. Managers and board members on a large contract shouldn't be doing that alone. So you need a construction manager, a construction professional to make sure you're getting what you're paid for. Another important thing is how they're paid. And now we're talking about the big contracts, not the landscape contract or the laundry contract, but on the big contracts. How is he going to be paid? One lump sum in the beginning, going to pay him up front? You're going to pay him as you go along? Are you going to withhold some money till the very end of the contract to make sure the job gets done properly? So one of the key things on a payment schedule that you want to look for is, I call it, don't let the contractor get ahead of himself. In other words, don't pay him for more than what he's done, because it's human motivation is once you're paid the money, you don't feel like doing the work. So as long as you have that motivation of, well, I'm going to do the next portion of work and I'll get my money. But if he's already been paid for more than he's done, then he's not motivated to keep working. So It's important in a large contract to have milestones in the contract, so you pay him as you go along. So he finishes this phase of the work, it's inspected. And in large contracts, you definitely need a construction manager. You need somebody in there telling you that, yes, he's finished phase one of the work, and that work was done properly and complete before he gets the check, and so on and so forth. And the other thing is a 10% retention is really helpful, because you hold 10%. The way that retention works is you hold 10% to the very end of the contract. In other words, he finishes everything, it's all done, now you do your walkthrough and inspection, and you still have 10% of the money. And that's there to make sure he comes back and finishes whatever it is that's not done. And you want like 30 days or a reasonable amount of time to complete your inspections, and then when he finishes the work to your satisfaction, that's when he gets full payment. So we've talked about, I want to talk about indemnity provisions. This is pretty common in most contracts, and what the indemnity provision is that if the contractor is sued, they want the association to defend them. If they're sued regarding some work of the contract, they want the association to defend them. And these are very, I'd say, touchy items for negotiation, and some of these are written very broadly, and if the association is, let's say we have a situation, the contractor does his work, there's an injury on the property because the contractor was negligent. Okay, so he leaves his ladder out, he leaves something out that somebody trips over and gets hurt. So now we have an injury, the vendors get sued for that. And so with an indemnification provision, the HOA is responsible. And why should the HOA be responsible when the vendor was negligent? So that's the thing we want to watch out for in these contracts. Is an indemnity provision is fine. I'm okay with it if the vendor was not at fault for the accident. But if the vendor's at fault, we don't want the HOA paying. And that's the way we write the indemnity clauses, is if the vendor is getting sued because of his own negligence, because he's at fault, then the HOA shouldn't be paying for his defense. So these are things that have to be looked at. Those things are buried in the contract. That's why you need legal review, because with an indemnity provision, the HOA not only has to pay his costs of defense, his lawyers, but they also have to pay any judgment against the contractor. So these are, kind of hidden time bombs in there. Time for performance, that's important too. You want to talk to your contractor, put a set time in for when the work is going to be done. I have a client right now that's, they signed a contract for a large solar project for their common area, and they built structures, carport covers and structures in the parking lot. And the work has been done, but it's been months and months and months, and it's not connected. So what good is it doing them? And they're getting really disturbed about the time of performance, but it wasn't specified in the contract. So there should be a time of performance, and penalties, or some kind of hammer that you can use, hold over the contractor's head so he gets the work done. So you want that specified in there. Permits and licenses, a lot of times the building permits are an extra cost, so you want to be clear on what those costs are, because it may just say permits are not included, but the permits could be thousands and thousands of dollars. So it's okay if they're not included, it's okay if you know about it, but you need to find out from the contractor how much those permits are going to run you. So that's also important. Talk about warranties. Also in the contract, you want a warranty on your work. You want that laid out. There's two kinds of warranties. There's the warranty that the contractor gives you for the labor, and then if there's materials like a new roof, there's a roofing warranty from the manufacturer. So there's two different kinds of warranties that you can get. And the thing with the manufacturer's warranty is that they have to have their representative come out and inspect the work before you get the warranties. So in other words, I'm the manufacturer and you're putting on my roofing shingles or my roofing tiles on your roof. I'm not going to inspect them unless you put them on right. And so I have a representative come out, and he checks it out, and if it's okay, he signs off on it. So that's something for you to be aware of, is when you want the manufacturer's warranty to be in place, because that's the one that lasts for 20 or 30 years on a roof, for example. So you want that in place, and the way you get that in place is you make sure that the representative for the manufacturer has signed off on the work, because if he won't sign off on the work that it was done properly, it wasn't done properly. So that's really important. And then the other warranty is what the contractor gives you, and that's on labor. So, and those are usually shorter. So those are the two things on warranties. And again, those should be in the contract. And the legal counsel for the association, that's something that they look at. But you as managers, you should be knowledgeable about that. Another thing is mechanics liens. And this is, I think everybody's heard of mechanics liens, but they're pretty nasty problem that an association can get itself into. So this is how the problem arises. You have your contractor, you're following the payment schedule, you're paying them on time, the construction manager is saying the work has been done fully and completely and it's done properly. So where can it go wrong? Okay, where can you get yourself in trouble? Where you can get yourself in trouble is the contractor has not paid his subcontractor. So he's hired subcontractors to do some of the work. He has to do, let's say he's doing decks. He has a lot of lumber, he has deck coating materials. He hired a subcontractor to do the deck coating, but guess what? He didn't pay his subcontractor. And in that situation, you may have paid him in full. He didn't pay his subcontractor. Those subcontractors can now file a mechanics lien against the association, and guess what? The association has to pay the subcontractors directly. So that's really serious. So it's important that the contract, how do you protect yourself against mechanics liens? All right, a property manager or the association will get notices from and they have to give you these notices of that they're the subcontractor on the job before they start the work. So you will get a notice from the subcontractors or the people that supply materials that they are supplying materials. And when you pay the contractor, you want a mechanics release from the subcontractor that they have been taken care of. And there's different ways of doing it. I'm not going to get into the details of how it's done, but you get this list of this called a preliminary lien notice. You get these in the mail, preliminary lien notice. And when you see those, that means there's a subcontractor and there's people supplying lumber or materials to the project. You need to make sure they get paid before the contractor gets his final money. Otherwise, you could be in big trouble. Termination clause. I like to have a clause in a contract, the big contracts or even the small contracts, that lets you out of them easily. Because if things are not going well, you want to be able to get out of the contract. And you want to negotiate the best one you can. But I prefer, if you can get them, they call them a termination for convenience or without cause. And if things aren't going well, you want to be able to end the contract. You do owe the contractor every money he's brought, all the work he's done to date. But and again, these might be tough to negotiate, but you want a way out of the contract if things aren't going well. Next, I'm going to talk about, I'm getting near the end of my time here, is the evergreen clause. And this is my real sore point on, not on the big contracts, but on the day-to-day contracts. These are the ones that keep you on the hook indefinitely. And the evergreen provision is this contract automatically renews for another 5 years if you don't terminate it within 2 months of the date you originally signed it, et cetera, et cetera, et cetera. So what the evergreen clause does is it says that it's a 5-year contract or a 2-year contract or whatever, but it doesn't end after 2 years unless you give notice that it ends. And it usually gives you a narrow window of time when you're allowed to terminate the contract. So if it's, if the contract is supposed to end on May the 5th, you have to give them notice by March the 5th. So you have March and April. And you have to just give it in that window of time. And if you do it too late, the contract then kicks in for another year or 2 years or 5 years. And that's really typical with a lot of vendors put that in there, and you don't want it. There's no reason the contract can't just end and then you renew it. I mean, the board should think whether we want to consciously renew this contract or not. So that's another thing you want to always look for. Even on the little contracts, you send it to your lawyer. If they spend 15 minutes, they'll pull that out right away and say, no, no evergreen clause. The other thing you can look for in contracts, the larger ones, is some kind of dispute resolution provision. If there's a beef with the contractor, go to mediation first, arbitration. But it's nice to keep it out of court. You can get, especially on smaller contracts, you can get a resolution a lot quicker that way. And typically, you want an attorney fees provision in the contract, because if there is a dispute with the contractor, the HOA wants to be reimbursed for the attorney fees it took to get relief. So that is my presentation, and if there's any questions, we can take them at this point. So,
Joel, how hard is it to get out of an evergreen contract? I have one with an elevator company at a new property. It was signed in '09. And is it difficult to get out of those?
yes, if the contract renews for another 3 years or whatever, unless they're not performing, unless there's a reason to terminate, or if there's a breach of the contract, they're not doing their work, yeah, they're on the hook for that.
And
for another 3 years.
in large projects, would you recommend that the HOA consider getting a completion bond or something equivalent in order to protect itself in case the work isn't done properly or it's not done, period?
Okay, well, that's a good point. The completion bond guarantees, it's a bond that guarantees that the contractor will finish the job for the price that he has put in the contract. So if he leaves the work and you have to hire somebody else and they're a lot more money, the completion bond kicks in. There's nothing wrong with them. The only downside of them is they're extra money, and the contractor doesn't pay for them. So that's extra money the association has to pay for basically insurance that he's going to be able to complete the job for the price that was promised.
And typically, if you're having a contract reviewed by an attorney, such as yourself, what kind of money is a homeowners association looking at to have a contract proposal reviewed?
So the typical lawyer answer is it depends, but it depends. It's an easy depends. So if it's a short contract for landscaper or the laundry or an elevator contract, I mean, I think maybe a half hour or so, $150, $200 tops to review the contract. Again, if you have a 30 or 40, 50-page contract for a $250,000 or a $500,000 project, yeah, you're going to run up several $1,000s in attorney fees to review it. But when you're spending that kind of money, you want the attorney to review it. And in the larger contracts, we will usually do an addendum and put in, because the contract is written typically by the vendor, by the contractor, and it's written for his benefit. So we want to make sure the contract is fair, you're on a fair level playing field, and then we actually write up an addendum, and we actually go the other way. We try to get more for the HOA, more protections for the HOA in the addendum, and then we negotiate it out with the contractor. A lot of the times, they're pretty flexible on these things, and we can get a lot of protections built in that addendum for the big contracts.
Go ahead, Deborah.
Thanks, John. Could you expand more on the escalator clause?
Yes. This would be an escalator clause is where you have a contract that the price increases automatically every year. So that some of them do it, according to consumer price index. But again, that's just something to negotiate. The thing just may say the price of our services increases every 5% every year, or 3% every year, or it could say we go by the consumer price index, and it goes up by that. But again, it's just something to look at, and it's all negotiable.
Okay, we have time for one more question. Harold.
When dealing with subs, can you put that in the contract as you're bidding it. I mean, I have an association that ended up having a sub brought in, and it was a company that they initially bid the project, and the association didn't select them, but the person who got the contract brought them in, and we had issues with the quality of work, which is what we were concerned about. So can you put in language in the original contract regarding subs and use of subs?
Yeah, definitely. We can put in any, the contract's free to negotiate, so we can definitely put in, you have to approve the subs, or we have to see a list of the subs before they're retained. Yeah, definitely can do that.
All right. Thank you, Joel Kriger. Let's give him a big hand.